Welcome to the She Said Privacy, He Said Security podcast. Like any good marriage, we will debate, evaluate, and sometimes quarrel about how privacy and security impact business in the 21st century.
Hi, Jody Daniels here. I'm the founder and CEO of Clover Advisors, a certified women's privacy consultancy. I'm a privacy consultant and certified informational privacy professional providing practical privacy advice to overwhelmed companies.
Hello, I am Justin Daniels. I am a shareholder and corporate M&A and tech transaction lawyer at the law firm Baker Donaldson, advising companies in the deployment and scaling of technology. Since data is critical to every transaction, I help clients make informed business decisions while managing data privacy and cybersecurity risk. And when needed, I lead the legal cyber data breach response brigade.
And this episode is brought to you by... Really? That was just awful. Okay. Clover Advisors. We help companies to comply with data privacy laws and establish customer trust so that they can grow and nurture integrity. We work with companies in a variety of fields, including technology, e-commerce, professional services, and digital media. In short, we use data privacy to transform the way companies do business. Together, we're creating a future where there's greater trust between companies and consumers. To learn more and to check out our best-selling book, Data Reimagined, Building Trust One Bite at a Time, visit redcloveradvisors.com. How you doing today? It's fall-like weather. Ooh.
Yes, you actually spent all of 7 minutes with me out on our enclosed porch enjoying the fall weather.
It was really quite lovely. But now we're going to talk about some really fun digital advertising today. And we have Daniel Rosenzweig, who is founder and principal attorney at DBR Data Privacy Solutions. He advises clients on legal and technical compliance with data protection and privacy laws, and counsels clients on the use of AI, AdTech, and privacy-enhancing technologies. Daniel's legal practice is unique in that he also codes and develops technical solutions to enhance his legal services. Dan, welcome to the show.
Thanks for having me. Really excited to be here.
That's your turn.
Are you sure?
Yes.
Alrighty then. So, Dan, who was subjected to this banter prior to going on the show, how did you get where you are today?
So I have been interested in technology for as long as I can remember. Was also very interested in politics and wanting to get an opportunity to be on the Hill. So where I went to law school, I wanted to use every resource I had at my disposal to just get on Capitol Hill. One of my friends at the time was at the Senate Committee on Homeland Security, and she had said to me, "Do you know anything about cybersecurity?" I said, "I do not, but I'd love to learn," and ultimately got a position there, and that's what threw me into it, and I fell in love with it ever since. And it's been an incredible, incredible experience.
Well, in our pre-show, we were kind of swapping funny weekend advertising stories, which I think might help set the stage for our discussion here today. I was visiting my parents recently, and I was looking at a couple interesting items that I was looking at purchasing and researching. And then the next morning, my dad says, "This is so fascinating. I got this advertisement." He clicked on Facebook. You guys have never heard of these before. And I thought, oh my goodness. They obviously had connected what I was looking for. I was on their Wi-Fi to his device and his Wi-Fi, and now he's getting all of my ads. And he doesn't understand. He goes, what's happening here? Why am I getting these ads? This is so fascinating. Thankfully, it was an item that was okay, that it was he could look at. But Dan, you were sharing kind of a similar story. And why are you giggling?
Because how come we don't talk about when I get the ads? It's for all these different women's fashion sites. And then I
really talk to your teenage daughter about
But
that.
then when I go and I make recommendations, I'm looked at like I know nothing.
You obviously didn't get the right advertising to you.
Well, it sounds like you now need to just, overwhelm them with other advertisements. So you should be searching for whatever you're interested in.
Yes.
And then we can,
Yes. But it also kind of showed a little bit of the inefficiency in my mind, right? We have all these technical tools that we're going to start talking about, and yet device A, device B, connected by an IP in a house via Wi-Fi automatically assumes those are the same and we should have the same advertising. So Dan, do you want to share your story a little bit?
Sure. Yeah. So a little even more moved. My cousin and my aunt were at my house this past weekend, and I am very interested in watches. So I was just, doing my typical searching online and, typical Googling and things of that nature. And my aunt started getting advertisements for watches, which again makes sense, very similar to the story you just alluded to, in that she was connected to my Wi-Fi. My cousin was not connected to my Wi-Fi. And by the time my cousin and my aunt got back to their home, they were now connected to the same Wi-Fi. And my cousin all of a sudden started getting advertisements for watches. So again, using that common denominator being the IP address, but it was interesting again that it was an IP address that wasn't necessarily associated with his device at all. It was just later down the road that they found that connection.
Yep. So in the land of targeted advertising, most people equate that with cookies. And then we have kind of the universe of cookie banners. And recently, I asked a number of different privacy attorneys, and it was fascinating to see the multitude of different answers. Some companies believe, and privacy professionals believe these things are opt out. Some people believe it's opt in. Some people believe no cookie banner. Some people believe a cookie banner, and companies are just confused on what it is that they're supposed to be doing. Dan, from your standpoint, how should companies approach this, and what should they be doing?
Yeah, so it's a great question. And I think ultimately, in a typical lawyerly answer, it always comes down to it depends and the context of which they're using their technologies. So, first and foremost, context is incredibly important as it pertains to what the goal is that the company is trying to accomplish. If we're talking about, advertising and ad tech traditionally, first off, there's technology way beyond just cookies, which we'll talk about. So the fact that it's just called a cookie banner and it pops up and talks about cookies, that can become a problem if it doesn't incorporate the other technologies that are going to be utilized. I think ultimately, because the US is typically, at least in the advertising space, typically an opt-out regime, notwithstanding some corner cases and exceptions, I typically would advise companies, depending on their risk posture and the technologies they're using, not to use a cookie banner. Really, because of other issues that can arise, like for example, dark patterns. Right, a lot of times the cookie banners will push one way or the other. Another instance is whether or not it's actually in coordination with the other disclosures like do not sell page and privacy policies, and whether or not it's accommodating other technologies such as the IP address that we were just alluding to, and server-side technologies and alternative IDs and all these other types of tech that are really, really important and considered personal information in certain contexts that just otherwise wouldn't be covered off by a cookie banner. With all of that being said, and we'll talk about this further, if ultimately a company chooses to use a cookie banner, that's great, and they want to be privacy conscious. Just make sure you're doing it correctly, right? Make sure it's actually doing what it says it's supposed to be doing from a technical perspective. Make sure you're assuming that the website and app will behave differently. Apps typically outside of certain functions of the app don't use cookies. So there are definitely considerations that if you're going to use it, make sure you're doing it correctly. And of course, this is just for the US. EU is a little different, and other jurisdictions where consent is typically required.
I'm just going to do a little plug. You're going to use a banner. Do not block the site. And I shouldn't have to accept your cookies to get to the site. I see that all the time.
Absolutely.
Dan, could you explain a little bit more just for people like me who aren't as conversant in the ad tech? What is the dark matter? See, I think of that in physics.
Pattern.
The dark pattern. I'm sorry. Thank you for correcting me, Jody. Could you explain to our audience what a dark pattern is and what the legal ramifications are of that?
Sure. It's essentially the concept of nudging the consumer to make a certain decision, or convincing them to do something subtly, or maybe not even so subtly. Maybe it's very conspicuous. So, for example, using the context of a cookie banner, the accept button is large, conspicuous, different color, and the deny button, if there even is a deny button, is small and doesn't really scream to the consumer, click me, click me. And laws are continuing, and regulators are continuing to focus on this for various different reasons, and it's been a big topic for regulators and particularly the FTC and other state AGs.
You mentioned a little bit that a lot of companies are focused on cookies, but there's a whole nother universe of alternate IDs. pixels, trackers, all different kinds that are out there. Can you elaborate and share what some of these are and what companies need to be mindful of?
Sure. So I'm sure everyone and the listeners, the podcast listeners, as well as both of you guys are aware that now Google has taken back the whole deprecation of third-party cookie statement. But regardless, cookies are just one of many technologies, and they're probably for various different reasons going to be changing within the ecosystem, regardless of the Google's deprecation of third-party cookie announcement. So what does that mean? Companies are now starting to rely on alternative technologies or technologies that have been around for quite some time, but are now getting a lot more runway and a lot more adoption in light of the alternative to cookies. So the most common one these days are literally what are called alternative IDs, which are simply just deterministic and probabilistic IDs that rely on typically an identifier that either is known to be associated with a user or reasonably known or volunteered by the consumer, for example, an email address, right? So they will provide their email address to the company. The company will then be able to generate an alphanumeric string, again, speaking high level here, that is then utilized for purposes of targeted advertising and other use cases. So that's one very common. Another one, which was briefly alluded to on previous podcasts I've listened to, which is awesome that it's getting a lot more focus these days, are server-side technologies. This is typically what's considered, or an example of this is a conversion API, also known as CAPI. Server-side technologies are simply when the company, or in this instance, maybe the first party, is the intermediary between the consumer and the third party, and the first party company will simply just share data directly from their server to the advertising company server or third party for advertising purposes and other things of that nature. Another common one is what's called advanced matching. This is kind of a combination of some of the others, and it integrates cookies and other types of technologies. But essentially what it does is it goes on a web form or looks for a web form and will scrape, for lack of a better word, data from that web form and then append it to someone's profile and things of that nature to then send them targeted advertising. The reason I bring up these three in particular is because these are distinct from cookies, right? A cookie banner typically wouldn't cover off these technologies, but for other bespoke configurations. But they certainly aren't considered quote unquote cookies. They work in conjunction with cookies sometimes, but they're not in and of itself a cookie. And that's an important distinction because of opt-outs and opt-ins and how cookie banners typically operate. Again, it wouldn't really pick up on these technologies.
That is actually the exact question I wanted to bring up, which was opt-outs. If I'm utilizing any of these other technologies, Jody, as an individual user, well, actually a different Jody, because in Georgia I have no rights, but move me to another state where I might have some, companies still have to manage that. With these different technologies, how do companies address the ability for a user to opt out?
Yeah, so I think for one, CMPs are starting to do a pretty good job at understanding and really pushing and working with their customers, which again are typically the first parties, to understand and navigate the distinctions between these approaches and these technologies. But you are spot on that ultimately a CMP is only as good as you guide them and as good as your business cases are. A lot of this will come down to what is the first party's obligations and what are they trying to accomplish and what technologies are they using. If they're using alternative IDs, you want to make sure that you have certain opt-outs in place. So for example, there are some vendors in particular that have specific opt-out provisions or technologies or configurations that first parties should be able to rely on. There are other instances where vendors have taken or made public statements or representations, whether through contract or again publicly on their website, that they will honor certain signals and treat it as an opt-out for purposes. So for example, the IAB's GPP and other types of technologies, if they see that signal or ingest that signal, they will treat that user as being opted out. But you are spot on that the typical cookie configuration technologies that are used for quote unquote opting out or even opting in, depending on what jurisdiction we're talking about, wouldn't typically cover these technologies.
I just want to add that it's really important when companies are looking at some of these different ID options, that they're really investigating that vendor and third party to help figure out how can they manage that ID. In a conversation that I had with a client, they were looking at a particular third party, and that third party had no good answer to how they were going to be able to manage the opt-outs. So we got a long list of privacy friendly, blah, blah, blah. And then when it came time to, okay, so what do you do when the user wants to opt out? They really didn't have a good question.
Yeah, so I would say there's pretty much two, and again, speaking kind of at a high level here, where there are typically, or at least most commonly, two approaches to this. Um, Again, assuming your CMP can help you with this, or you have internal, dev folks that can kind of help align this. So we have what's called suppression, which essentially means you just turn off the hose, right? So if a user clicks opt out on your opt out page, you just turn off any what are called, network traffic calls or the transmission of information to these various, third parties for purposes of targeted advertising. Sometimes that can be throwing the baby out with the bathwater, right? You're probably turning off more than you need to, but that sometimes is the best case for some companies, depending on their risk posture. Another option, which is incredibly common, is sending out a signal, right? So like the GPP signal, from IAB or other types of signals. Some vendors, Facebook is an example, Google to an extent, they've taken positions with respect to IAB, but will have their own bespoke opt-out signals. But essentially, what happens in the alternative ID context is a user will opt out, right? They'll go on that first-party website and click the opt-out toggle, and then the third parties will receive a signal, literally like it's an actual signal, that will indicate that this user has opted out. And that's pretty much the two common ways to do it. Again, there's definitely some nuance there. You don't want to, make sure that you're working with your internal stakeholders and others to kind of make sure it meets your business needs. Because the last thing I would say on this, and I'm sure we can talk about this further, is these configurations, and Jody, I know we've talked about this previously, are not just from a legal perspective. These can have real business implications, right? So think about publishers these days. Publishers in particular, big media companies, they heavily rely on advertising revenue. And there are certain instances where their disclosures are adequate and everything is good to go, but they have misconfigured one of their technologies, right? And this can ultimately result in a big business loss, right? So maybe they've misconfigured their technology to treat users as opted out by default because they were messing around or having to figure out these bespoke configurations for alternative IDs and others, and treating users as opted out by default. Right? I've worked with companies that have done that, and they lose a ton of money in ad revenue. And again, this isn't necessarily a problem from a legal perspective, right? They're complying and they're overly complying to instances where they have to, but at the end of the day, this is an instance where they don't have to. And I think it's important to weigh that against what your business is, right? And how are you operating your business, and what business goals and objectives do you have?
Really well said. Thank you. And I also really appreciate the two different opt-out examples. So thank you.
Sure.
So Dan, while Jody may talk about softballs, I want to throw a little knuckleball out there for the two of you.
Because you're a knucklehead. Oh,
or maybe Jody could get rights if she lived in Colorado for half of the year.
Mm-hmm.
But question. So Dan, going back to your days where you were really interested in Capitol Hill. So obviously on this podcast, you and Jody and I have been discussing AdTech, with the broader implications being, how do you appropriately and legally advertise to people? But my question is how do you prioritize the importance of helping companies understand how do you market to people with all of the kinds of data brokering that goes on? Because as a person who's not as involved in ad tech, what concerns me is I don't even know where my data really goes through all these different brokers who sell my data to advertisers. And I'd love to get maybe both of your perspectives on how you prioritize when we talk about the ad tech stuff versus all of the data brokering that goes on with our data that I think most regular people they don't understand it.
Yeah, so I think you're right, and to be confused, concerned, et cetera, because there's just so much going on behind the scenes that pretty much have become a bit complex and difficult to navigate. I think from the data broker perspective, regulators are catching on, and legislators, and they're starting to specifically legislate for data brokers, right? We have data broker registration laws in place. We have other instances where they have to, have to offer, certain specific rights and opt outs and deletion requests and things of that nature. And I think ultimately, having consumers be made aware of what's happening through a privacy policy or a notice is incredibly important. I think ultimately, though, another side of this is what is the first party in this instance? Because as a reminder, the data broker wouldn't be the first party, right? The data broker, by definition, is typically an entity that does not have a direct relationship with the consumer. The direct relationship here is typically the first party. They're obtaining data and things of that nature. And it's really where that first party has an obligation to make sure that they're disclosing to consumers what their rights are, making sure they're clear and transparent with respect to their data practices, and most importantly, not conflicting with what they're actually stating, right? So this goes back to what Jody and I were saying before with the cookie banners, is ultimately if you're going to make certain representations from a technology perspective and you don't want to confuse the consumer, you need to make sure that what you're stating is clear, concise, accurate, and actually in accordance with what your technology is doing to kind of help bridge that gap and messaging between how the business operates as well as how the consumer is interacting with the technologies on your website and app.
So speaking of representations and how, if I choose to set one up or how I'm managing my consent management platform from an opt-out perspective, a lot of companies feel like, oh, I set it up, I'm good. Maybe I even tested it the first time, and then they go on their merry way. You and I both know things break, new IDs and trackers are added, new pages are added, websites are updated. We're always talking about you need to have a review process. You need to have an audit in place. You need to have a pixel governance process to even know when to put one of these pixels, trackers, IDs on the site. I'd love to hear from you. What do you think of how often companies should review what they have in place, make sure it's working properly, and any kind of process that they might want to think about for sites and mobile apps? I know we talked just a little bit about mobile apps, but they're included too.
Yep. No. First off, I'm glad you made that distinction because it's a big one, right? Mobile apps just technically behave and operate differently than websites, and I think a lot of what is discussed with respect to cookie banners and things of that nature, again, don't necessarily apply to mobile apps, and arguably more people are using their mobile apps and on their phone. Again, it's an anecdote, but I know that a lot of people are on their phone as often as they are on their desktops, and it's really important consideration. I think to your question, I think there are really a couple of things that can be done. First and foremost, from a process perspective, it's really important to have a cadence of meetings between the internal stakeholders, right? Privacy, legal, marketing, product, et cetera, folks that have visibility into what's happening, but distinct viewpoints that all have an impact on one another. I've noticed that actually the larger the company, the larger the organization, the more problems they end up having from a data privacy perspective because marketing is working on one thing. They don't necessarily keep legal in the loop because they don't necessarily think they have to. They rely on the vendor's representations. Oh, we're going to introduce this privacy safe tracker and all these different things. And before you know it, they take the point of view that we're good to go. They introduce it. Legal then comes in later. They're like, wait, what's going on? And then the product team comes in and they're like, wait, how do we fix this? And it's just a bunch of stuff going on that ultimately raises to a level of concern with respect to privacy compliance. And that's what these regulators are focused on, right? Like these laws were passed as a result of these technologies. So it's really important that the stakeholders who have very important perspectives come together. And I typically recommend, depending on the size of the organization, monthly or quarterly meetings. It can be a 10-minute meeting. Just say, hey, what's on the agenda? What are we looking for? What technologies are we looking to operate? What are our business goals and things of that nature? The other side of it, and this is incredibly important, is technical testing and auditing, right? It's really important to look under the hood to see what's actually happening. There's a bunch of different technologies that can be operated on a site or an app. A lot of technologies integrate other technologies through third-party code and third-party SDKs and things of that nature, which leads to a bunch of different data that's being collected and shared on apps and websites. And I've actually created and generated and developed my own technology that I work with clients on which does just that, right? It provides a digestible report of all of the data being collected and shared on apps and websites, and then provides them remediations and root causes to come together and act as that translation layer. So legal, marketing, and dev can come together and say, hey, look, we're collecting such and such data from such and such party, and we're sharing, hashed email with a bunch of different third parties. Is this intended? Do we have our privacy policies up to date? Do we have our contractual obligations up to date? And things of that nature. And it's really, really important to have an understanding of what's happening from a technical perspective, because that's what regulators are doing too, right? The New York State, AG came out with guidance a couple months ago at this point. Constantly, if you look at the regulators' activity, it's our companies' technology supporting what their statements are, and often they aren't. And that's just because there are a lot of cooks in the kitchen at organizations, and they really should come together and talk with one another and collaborate to really make sure that they're doing what they need to do to comply and also meet their business objectives.
And I would add, in addition to regulators, customers are looking too, especially in the B2B context. If you have an outdated privacy notice, your cookie digital tracker scenario is kind of a mess, and I'm looking to do business with you, then those companies are evaluating, well, if you can't do your privacy well for yourself, how do I believe that you're going to do it well for me? And I've had those conversations. So from a B2B perspective, I mean, I think everyone should, but especially those from a B2B, anyone can tell. Regulators too, but your customers.
I would also add, it's related, is that technology can be incredibly powerful as well, right? This isn't always just a compliance exercise that you dot your I's and cross your T's, which is important. But again, this can provide some real business strength as well. So I vividly remember, and it's still ongoing and it's still happening with respect to, the VPPA issues, right? The Video Privacy Protection Act and the utilization of certain third-party technologies that, allegedly violate the VPPA by virtue of sharing personal information in conjunction with video information to third parties. Now, a lot of lawyers would tell companies, and this is true from a pure legal perspective, a lot of lawyers would tell companies, just turn off these technologies. Are they becoming legally compliant? Arguably, yes. I mean, they're pretty much removing all of the risk. But ultimately, particularly for media companies, for publishers, being told to turn off one of their core functions and technologies in order to meet their business objectives can have a huge hit on revenue, like a huge hit on ad revenue and a huge hit on their bottom line. That got me thinking there's got to be some sort of technology that can support this. So looking at technical development materials that are made public, I was able to work with companies and figure out ways, okay, we can still use this technology, but we're going to turn off, the transmission of video information to these third parties, right? So you're still getting to use it. And is it foolproof? No, but ultimately it's a cost benefit analysis. What is your risk posture? What is your bottom line? What are your business objectives? Because ultimately I'm finding often a lot of companies are given advice to just turn technologies off or turn them on whole hog. Right? There's always some nuance. Technology is very, very powerful. You can control which data is being sent to a lot of these third parties. It's not a matter of just turning them on and off, whole hog, because that can have a real implication, either over complying or under complying, and can also impact the business as well as the legal posture and risk posture.
Yeah, that makes a lot of sense. And I've seen the same on the advertising side as well. A good evaluation makes a lot of sense.
So Dan, I'm going to ask you a very specific question. So when you're out and you're talking to someone like me who's not as conversant as the two of you are with AdTech, what can I do as a consumer to protect my privacy better or be more aware when I'm online? Do you have a tip you might share with the audience from that particular perspective?
Yeah, I think your perspective will come down to the particular brand and company that is most important to you. To me, it comes down to, is there a brand or company that I value and I visit every single day and I'm okay with supporting their, ad revenue model and I'm okay with that? Great. Then that's something where you can consider, and maybe you're a little more friendly with the type of data that you want to be providing them. Again, assuming that this company is providing you adequate disclosures and giving you the choices that you rightfully deserve. There are some other companies that maybe you say, you know what, I don't want any part of this. I don't really like this. You can either, configure the GPC signal, which we didn't talk much about, but it's essentially a system-wide opt-out on your browser, or you can go to that specific website yourself and opt out and issue a request to see what type of data they have on you and exercise those certain rights. I would say a lot of companies these days, particularly larger companies, are actually really trying to be privacy conscious here. And a lot of them are actually using certain laws as a baseline to kind of offer certain rights and choices to consumers, even if they don't fall within one of the particular states that require it. I have a lot of clients that are saying, you know what, privacy is the future here, and I really want to help my consumers. And I think privacy, being privacy friendly and privacy focused, is a good business opportunity. And telling consumers, hey, fine, you're not in California, you're in Georgia, we'll still work with you and provide, and if you give us an access request or a deletion request, we'll honor that. But yeah, I think it comes down to what you as a consumer are comfortable doing.
I think you two should collaborate on one of those LinkedIn boards where you show people step by step how to opt out globally using your browser.
We could. We probably forget that the average consumer does not know how to do all of that. And I see it all day long with people just seeing these banners and not knowing what to do. My dad is a great example.
Yeah, I think one thing an average consumer could do, and I know one of your guests had suggested this on a previous podcast, and I think it's great. Just submit a request for the data they have on you and see what data they have on you. If you're comfortable with that, great. If you're not and it's incorrect, you can ask them to correct it. You can ask them to delete it. Simply just go to the privacy policy, and it should be clear within the portion of the privacy policy. Again, not the best thing, but or the most user friendly. But if you are interested in this, there are ways to kind of navigate this and move forward.
Now, and you are not advising on privacy and AI, which we did not have too much AI in this podcast. There is still just good old privacy. What do you like to do for fun?
So I'm a recent father. My daughter is almost 10 months. It's our first. So whenever I can, just go and hang out with her and do fun things. She's now at the age where she's really just has a real personality. And I really like to swim. So she's starting to swim with me, which has been really, really fun. So yeah, anytime that I have to hang with her, I take it.
Well, we're so glad that you joined us today to share all the amazing information that you did. And if people would like to connect and learn more, where can they go?
Yeah, just always available on LinkedIn, and shoot me a note. You can shoot me an email at dan@dbrdataprivacy.com. Always looking to talk to folks about this stuff. It's something I'm really excited about and love the day-to-day job that I have. And thank you for having me.
Absolutely. We're so glad that you're here. Thank you so much. Have a great one.
Thanks, you too.
Thanks for listening to the She Said Privacy, He Said Security podcast. If you haven't already, be sure to click subscribe to get future episodes and check us out on LinkedIn. See you next time.